G'day everyone, and welcome to the second video in week 12 of our Legal Ethics and Trust Accounting course. This week we're looking at the consequences of a failure to comply with the ethical rules. In the first video we looked at the worst form of misconduct, termed professional misconduct. We learned during the first video that notions of professional misconduct commence from the common law and the court's inherent right to regulate the conduct of its practitioners. Under the common law, there was simply what came to be known as professional misconduct, and we learned that the meaning of professional misconduct was taken from the case of Allinson. And the Allinson definition was where a professional in the pursuit of his profession has done something with regard to it which would reasonably be regarded as disgraceful or dishonourable by his professional brethren of good repute and competency. We also learned, however, that the Allinson definition sets the bar pretty high. A person could still practice quite poorly without reaching the level of being disgraceful or dishonourable. And we learned that the professional conduct legislation has a go at fixing this problem by creating a lesser form of professional conduct called unsatisfactory professional conduct. In this video, we're going to look at unsatisfactory professional conduct and how it works. Now, because professional misconduct came from the common law, what you'd probably expect is that the Parliament would have started with the Allinson definition of professional misconduct and then added a lower level of misconduct underneath that, yeah? Well, just to make the lives of law students difficult, the Parliament didn't go about it that way at all. Instead, they started with a definition of unsatisfactory professional conduct, and then they said professional misconduct is just the worst version of that. Let's have a look at the statutory provision and you'll see what I mean. We start with section 418 of the Legal Profession Act, which defines unsatisfactory professional misconduct. It defines it as conduct of an Australian legal practitioner happening in connection with the practice of law that falls short of the standard of competence and diligence that a member of the public is entitled to expect of a reasonably competent Australian legal practitioner. So you can immediately see that this is a much lower standard than the Allinson definition. Conduct doesn't have to be disgraceful or dishonourable. It just has to fall short of the expected standard. And the standard is no longer the standard of other practitioners. The standard is that which a member of the public might reasonably be expecting. So there's a lot of lower level conduct that would not get caught up by the Allinson definition, but it'll certainly get caught up by the statutory definition of unsatisfactory professional conduct. The bar is a lot lower. The statute then, as we learned in the last video, states that professional misconduct is unsatisfactory professional conduct that involves a substantial or consistent failure. See how it works? The Parliament said, here's unsatisfactory professional conduct. Professional misconduct is pretty much just the worst version of all this. Section 420 of the Act then outlines a range of types of conduct which, depending on the circumstances, can sometimes be professional misconduct and they can sometimes be unsatisfactory professional conduct. Have a read of them. It's difficult to see why the Parliament really felt the need to do this, except perhaps to remove any doubt the parliamentarians might have felt existed. It seems pretty clear that any conduct which is unsatisfactory professional conduct is also capable of being professional misconduct if it's sufficiently substantial or consistent. Let's have a look at an example from the cases to see this rule in action. I want to take you to a case called the Legal Services Commissioner and Graham. It's a QCAT case. Mr. Graham was a costs assessor engaged to assess legal costs under the Legal Profession Act 2007. He was engaged in March 2010 and indicated that the work would be complete within about 8 weeks. However, by the end of January the following year, he had still not completed the costs assessment. The client complained and the Legal Services Commission took action, alleging professional misconduct. The Legal Services Commission relied on some other cases that had involved delay by the practitioner. In these cases, Busser and Petschler, the practitioners had taken no steps in 5 years. The tribunal found that while Mr. Graham's delays were unsatisfactory, they did not rise to the level of being substantial or consistent. They were therefore unsatisfactory professional conduct, rather than professional misconduct. The tribunal said those events are disturbing and inexcusable. While the delay was not of the order of the lapses that occurred in Busser or Petschler, and does not fall to be categorised with the terms used in section 419, substantial or consistent, or such as to justify a finding that the practitioner is not a fit or proper person, it constitutes conduct which, under the definition in section 418, falls short of the standard of competence and diligence that a member of the public is entitled to expect of a reasonably competent Australian legal practitioner. See how it works. First, the tribunal or the court established that there is conduct which falls short in terms of the standard of competence and diligence, and then the court considers whether the conduct reaches the level of being a substantial or consistent failure. If it's just a mere falling short, then it's unsatisfactory professional conduct. If it's substantial or consistent, then it's professional misconduct. The distinction between unsatisfactory professional conduct and professional misconduct also shows up in terms of the penalties applied. Obviously, you would expect lesser forms of misconduct to attract lower penalties. That's hardly a newsflash. However, there is also a variation in the objective of the sanctions or the penalties. The objective of the penalties for professional misconduct are first and foremost the protection of the public. When a practitioner who's been guilty of professional misconduct is struck off or suspended from practicing or even just publicly reprimanded, the effect is to either protect the public by stopping them from engaging that practitioner at all, or else to protect the public by making it publicly clear that this practitioner has been reprimanded. The sanctions for unsatisfactory professional conduct, on the other hand, are much more focused on improving or developing the practitioner so that they're then able to meet the required standards of competence and diligence. So, for instance, they might be required to undertake CPD, they might be required to undertake meetings with a mentor, they might be required to undertake another period of supervised practice. Can you see the objective is not simply to punish the practitioner, but rather to make them a better one? So, at the end of the second video in this, our final week, we've now met both categories of misconduct: professional misconduct and unsatisfactory professional conduct. In the third video, we're going to take a closer look at the usual sanctions that get applied for these types of misconduct. See you there.